That should be okay. We are now streaming live. This is the Kansas Court of Appeals sitting afternoon docket. We have remaining two interconnected cases. They're Allen, Gibbs, and Houlik et al. Versus Mark Ralston, same plaintiffs versus K. White. Both defendants are represented by the same counsel. Let me introduce my colleagues sitting with me today. Judge David Bruns, who's been on our court about 10 years after a distinguished career on the Shawnee County bench. And also joining me is Judge Leslie Isherwood, one of our newer judges, who enjoyed a distinguished career as an appellate advocate with the Sedgwick County District Attorney's Office. So she is very familiar with what we do. She's just changed where she sits. I'm Gordon Atchison. I've just passed my 11th anniversary on the court after an extended litigation career. Let me tell you how we want to approach these cases. I mean, since they were tried together and have hugely overlapping issues, we're going to take this as essentially one appellate argument. We are not going to call the cases separately. Mr. Ralston's case was technically set for 30 minutes and Ms. White's for 15 minutes. We will combine those. Each side will have 45 minutes. Of course, you're not obligated to use all that time. Counsel for the appellants may divide that time, reserving rebuttal, but we will expect counsel to make arguments for both Mr. Ralston and Ms. White during that time. Counsel for the appellees will have 45 minutes sandwiched in between that. So we will proceed as if these are consolidated cases, at least for purposes of this argument. And with that, let me turn it over to counsel for the appellants. You may proceed.
May it please the court, Charles Millsap from the police and going firm in Wichita appears as one of many counsel representing Mr. Ralston and Ms. White. Also appearing, as you know, is Joseph Alonso from the Gregory Doyle firm in Marietta, Georgia, and Joseph will be making the oral arguments today on behalf of the appellants. He was admitted at the district court level on my motion and tried the underlying jury trial, and has also been admitted in this court for these particular cases. Thank you.
Thank you, Mr. Millsap. Mr. Alonso, would you like to reserve a portion of your 45 minutes for rebuttal?
Yes, I would like to reserve 15 minutes.
That's fine. Please proceed.
Thank you very much. Good afternoon, Your Honors. It is an honor to appear before you. I want to start just by making note that although the appeal issue that we raised regarding the attorney's fees issue is important and we are not waiving it, I will not be addressing it in my presentation today because if the other relief that we have requested is granted, it essentially takes that attorney's fees award out of the equation. I'm going to start my presentation today by making two primary foundational points that go to the entire body of both this case and the arguments that I'll be making today. The first one is that this entire case is about my clients, Mark Ralston and Kay White, who I will refer to as Ralston and White, of taking a client list from a company named LPL and using that list to solicit clients. The second foundational issue that I want to make from the very beginning is that aspects of this case can come across as confusing or convoluted. And I believe that arises in large part because both Mr. Ralston and Ms. White simultaneously work for different companies. Now, to somebody like myself or others who are in industries where you only work for one company at a time, that might seem unusual. But in this industry and in this circumstance, it's perfectly normal, even common, for people like Mr. Ralston and Ms. White to work for different companies simultaneously. In this particular instance, some of the companies were plaintiffs to this case. Allen Gibbs, an accounting firm, and some others that I will get to momentarily. When Mr. Ralston and Miss White joined Allen Gibbs was an accounting firm that had accountants and was regulated by the Kansas Board of Accountancy. When Mr. Ralston and Miss White began working with Allen Gibbs, the accounting firm, they simultaneously began working with other companies. Initially, one was called Mass Mutual. We referred to it by its initials, Milisi, in our briefing. That company was completely different and unaffiliated. It provided different services, specifically what are called broker-dealer services or investment advisory services, stocks and bonds, if you will, investment advice. Now, these two different companies, these two different sets of companies are covered by different regulations. The financial firms, initially Mass Mutual, is governed by the Securities and Exchange Commission, sometimes referred to as the SEC. It's also regulated by an organization called the Financial Industry Regulatory Authority, referred to in short as FINRA. Now, Mr. Ralston entered into a contract with the accounting firm Allen Gibbs, and he entered into separate contracts with the other companies that provided other and different services. Now, let me say also from the outset that the maximum dollar amount contained in the pretrial order of this case was $818,000. And yet, at the end of the trial, the jury awarded $2.3 million, essentially for Mr. Ralston and Ms. White having taken a client list and used it to solicit clients. The reason that happened is because the jury awarded first a liquidated damages clause for the taking and using of a client list to solicit clients, a second liquidated damages award against Mr. Ralston for, once again, the taking of a client list, an award for conversion against both Mr. Ralston and Ms. White for the taking of a client list. And on top of that, damages for breach of fiduciary duty, once again, for taking of a client list. And there's a little bit of nuance to that, which I'll obviously get to. Let me make one other point before I move on. It is absolutely uncontested, taking into consideration all of the appellate briefs that have been filed and taking into consideration the entirety of the record, which is voluminous, that Kay White accessed the LPL computer systems, obtained LPL account information from her home, and it was from there that she retrieved the list. That is the language utilized by the plaintiffs in their brief on page 11, in their response brief to Kay White's appeal. Now, let's talk about the contracts. First of all, you have Mr. Ralston's contract with the accounting firm Allen Gibbs. It was signed in 2003. It was titled Employment Agreement, and it uses a tool from the very outset called a defined term. A defined term is a very common legal tool. It is usually designated by having a list of persons or entities, and then it will have parentheses and quotation marks. And in this case, the word that was used was employer, and it had a capital E, obviously, which designated it as a defined term. That I'm going to be referring to it during my presentation today as capital E employer, so as to avoid any confusion as to whether I'm referring to the defined term in the 2003 employment agreement or just the word generally speaking employer. The two are obviously not interchangeable. Now, when Mr. Ralston entered into this 2003 employment agreement, it had two parts. It had a main body part and it had an addendum. At that time, one of the plaintiffs, AGH Wealth, didn't even exist. And so when we look at that document, when it was executed, AGH Wealth was not a party to that agreement, nor was it included in the definition of the defined term capital E employer. Now, Mr. Ralston and Ms. White, when they began working with Allen Gibbs, the accounting firm, they also began working, as I mentioned, with a financial firm called Mass Mutual. We refer to it in short as Milisi. In 2008, for a variety of reasons, Mr. Ralston and Ms. White stopped working with Mass Mutual. They maintained their relationship with Allen Gibbs, but they moved from Mass Mutual to another financial firm called LPL Financial. They contacted their clients at Mass Mutual, and all of those clients moved their accounts from Mass Mutual. They opened up LPL accounts and they moved their accounts to LPL. Now, let's take a look at very specifically the terms contained within the 2003 employment agreement executed by Mr. Ralston and Alan Gibbs. First of all, it contains in Section 9 and the main body of the agreement a confidentiality clause. That confidentiality clause relies upon the defined term employer, and it says that Mr. Ralston is not is to keep confidential information about the capital E employer's clients, that is Alan Gibbs's clients. That provision also clarifies that the confidentiality obligation does not apply to information which is readily ascertainable absent Alan Gibbs. The 2003 employment agreement in its main body also contains a non-solicitation provision. The terms of the non-solicitation provision, we believe, are very clear. First of all, it says Mr. Ralston is not to solicit the employer's, capital E employer's clients, that is Alan Gibbs's clients. It also specifies, as is required under Kansas law, for a restrictive covenant to be enforceable, the scope of what it is that he is not supposed to solicit. And the scope is, quote, products or services the employer now offers or provides to clients. Now, I wanted to point out now that in plaintiff's response brief to our brief on page 25, they say that it is disingenuous for us to have made the argument that that 2003 employment agreement only applies to accounting services. I would want to point out that not only is it not disingenuous, but under Kansas law, that's all that it could have covered. At that time that Mr. Ralston entered into that contract with Alan Gibbs, I would just point out also under Kansas law, under the Alan Gibbs case, obviously that's the same name as the company, but the two cases are unrelated. Restrictive covenants are considered, when considered by courts, courts are to construe restrictive covenants strictly against the company that is implementing their restrictions. Now,
Counsel, let me ask you a couple of questions then on this before we get too far removed. I'm looking at the 2003 employment agreement, and of course you've referred to Alan Gibbs in Houlik LC. There's also listed Trusted Advisors LLC. What is Trusted Advisors LLC, or what was it?
Excellent question, Your Honor. So Trusted Advisors was dismissed from both cases prior to the trial. I don't have at my fingertips precisely the timing of when that occurred. I don't believe that at any time Trusted Advisors provided services to the public. And I don't.
Do you know what type of firm it was? I mean, did it provide accounting services, financial services, a holding company? What was Trusted Advisors LLC? If there's evidence in the record to tell us.
You know, I'm hesitant to guess, Your Honor. I don't want to be wrong about it. I am highly confident, however, that they were fully and completely dismissed from this case prior to trial.
Right. But what I'm trying to figure out is what services they offered, because you just made the argument that the only thing this contract could cover is accounting services. So I'm trying to figure out if that's what they provided or did they provide something separate. And then, of course, it does say, and their affiliated companies, just to reflect or recollection on that. But you may proceed.
Absolutely. So to answer those questions.
Let me jump in there because I have a question sort of along the same line. And it has to do with the 2008 addendum, which that's the one that I think that adds AGH Wealth Advisors. And it seems to me it also expands the language to it includes these companies, but it's not limited to those companies. And so I'm wondering, why isn't LPL within that broad framework of an affiliated company, since it was necessary for the work that Ralston was doing, and it gets tied back into AGH Wealth, and then to those companies are applying or providing auxiliary services that AGH didn't as an accounting firm, but they're all affiliated in some fashion, or are they not?
So I believe there are approximately 3 questions out there, and I'd really like to answer all 3 of them. I'll try to take them in order if that's okay with your honors. The
I think
first
it's all
question-
one question I asked badly,
Sure,
but go
absolutely.
ahead.
So the question about affiliate. Affiliate means a company that is a subsidiary company, a sister company, a company with shared ownership. And so no, LPL is not an affiliate.
Well, I
company.
was using it more generically than that.
Sure.
That
So
they're necessary to the services that Ralston was providing. And AGH was looking to, again, provide these allied services. But go ahead.
Sure. So technically, LPL is what's called an unaffiliated company because it does not have a legal affiliation with Allen Gibbs. It could possibly be argued that it has a contractual relationship with AGH Wealth, but not one with Allen Gibbs. Just to briefly jump back to the trusted advisors question, trusted advisors did not offer any services to the public that would have included it within the contractual term services now being provided. So to return to this topic, Your Honor, LPL provided what are called broker-dealer services. They were regulated by the Securities and Exchange Commission. And going to the 2008, so the question is, if AGH Wealth and LPL weren't parties to the 2003 employment agreement, how did we get down a path to where AGH Wealth was deemed to be not just a party to the 2003 employment agreement, but included within the defined term employer? And that was through the 2008 addendum. The issues related to the 2008 addendum are this. One, the 2008 addendum by its own terms only replaced the 2003 addendum. That would be accurate as a natural operation of law when you read it on its own terms. However, the 2008 addendum goes even further than that. It actually explicitly says within it, this 2008 addendum leaves the underlying employment agreement's terms unmodified and unchanged. And so what it explicitly did not do was amend in any way, shape, or form either the defined term employer in the original 2003 employment agreement. Therefore, it did not impact either the confidentiality clause, which only related to employers' information, or the non-solicitation clause, which related only to employers' clients. There is also in the 2008 addendum the additional question that you asked about LPL. What was going on during this period with the full knowledge of Allen Gibbs and AGH Wealth is that LPL had an entirely separate contractual arrangement with Mr. Ralston, with K. White, and with AGH Wealth that contained different terms that related to the providing of the broker-dealer services, different terms related to the providing of the investment advisory services, and specifically different terms as it related to the client information belonging to LPL. In other words, Mark Ralston entered into a contract with Allen Gibbs about Allen Gibbs's client information. He entered into a separate contract with LPL and AGH Wealth about LPL's client information. Those are 2 different, if you will, buckets of client information, both subject to very different regulations, both subject to very different levels of security and treatment by the government and by the regulators. And Mr. Ralston had very different rights and obligations, contractual rights and obligations, as it related to Allen Gibbs's client information and as it related to LPL's client information. Now, to take just a brief, yes, sir.
It seems to me what you're arguing, and maybe I'm not hearing it right, but it seems to me that the plaintiffs in this case wanted to prevent people that they were paying and working with, including Ralston and White, and I presume other people, from walking off with information about the clients that were being serviced. And it seems to me what you're saying is the plaintiffs did a crappy job of crafting a contract to carry that out. Is that the defense here?
No, Your Honor, it's different than that. The plaintiffs.
Okay, what is it? That's what it sounds
sir.
like. I mean, I didn't try a huge number of cases, but I tried a fair number. I could see where 12 jurors sitting here listening to that say, this is just a big shell game. I mean, they didn't want the secret information walking out the door, and that's what happened. And explain to me legally why it is the jury didn't get this and what the jury did wrong.
Absolutely. And there's two answers to that question. So first of all, it wasn't a mistake and it wasn't a screw up. The accounting firm knew exactly what it was doing when it entered into a contract with Mark Ralston. Similarly, AGH Wealth, LPL, and Mark Ralston entered into literally hundreds of contracts. They knew exactly what they were doing. It wasn't a mistake. They were accomplishing the goals they wanted to accomplish. Now, when Mark Ralston was working with LPL, LPL made a decision. It said, we are going to enter into contracts with other firms that is going to allow the sharing of client information. If the plaintiffs had a problem with that, they were perfectly free to, one, draft up a new contract and try to implement a new contract, or two, they could have said to LPL, we refuse to abide by these terms that you've asked us to sign off on, but that's not what they did. Instead, AGH Wealth proceeded to sign hundreds of contracts with Mark Ralston, with LPL, and with the clients that specifically entitled Mark Ralston to take LPL client information from LPL and to disclose it with LPL's contractual counterparties. So I don't think that it was a mistake. And I believe that these are sophisticated parties that knew precisely what they were doing. And frankly, I think they knew what they were doing at trial when they made a lot of efforts to try to confuse the plaintiffs, as in who's a party to what contract. The other answer to your question is that the trial court issued a ruling on a motion in limine and denied a motion for directed verdict, denied a motion for judgment on the pleadings, and denied a motion for summary judgment related to a number of our claims, and said that Mr. Ralston and Ms. White would not be permitted to share with the jury or present evidence on the fact that LPL, AGH Wealth, Mr. Ralston, Ms. White, and the clients had all entered into contracts that permitted Mark Ralston to take, and K. White to take client information from LPL and share it and disclose it to use it for a specific purpose, that is to solicit clients. Not only did the trial court prevent us from presenting evidence of the separate contractual arrangements that AGH Wealth and Ralston and LPL had entered into, they then required that those contracts that AGH Wealth had signed hundreds of times be redacted to remove and to hide from the jury the information that would have shown that Mark Ralston had specifically and explicitly been given permission to take this client information. But the trial court went further. In the resignation letter that talks about the explicit permission Ralston had from LPL and AGH Wealth to take this client information, they required that to be redacted. And it went one step further. Mr. Ralston and Ms. White were prohibited from even fully and completely answering questions at the trial when the accurate answer would have required them to talk about these issues of being explicitly permitted to take the client information. So in other words, you've got these two contracts. One of them was completely removed from sight of the jury, and not just removed, but no reference to it, no discussion of it, and any related documents that made reference to it were all redacted to keep that away from the jury.
Counsel, to try to simplify your argument a little bit here, your defense, at least to the contract portion of the claim, was that your clients had a right to take this information, pass it on to Morgan Stanley. Is that at least a fair summary of what your defense would have been?
Yes, Your Honor, and not just a right, a contractual right.
Right. Okay, I understand that. We only have a limited amount of time here, so let's make sure. I think you want to answer our questions so that you get to know what we want to hear, not necessarily what you want to tell us. So, assuming that is true, was an order in limine actually entered?
Yes, Your Honor.
And did you proffer any of this evidence that you wanted to present at trial? Is it all part of the record, at least on appeal?
Yes, absolutely, Your Honor.
Okay. So everything that you wanted to present, you have now at least put in the record on appeal. We have it in front of us.
Not exactly. So we presented a proffer that included both documents that we wanted to rely upon, arguments we wanted to make, and testimony that we thought we would have been able to get from the witnesses. What that stops short of, though, is what would have actually happened at trial, right? I mean, it's important for
Well,
us.
it's a fluid. Yeah, we don't
Absolutely.
know that. Yeah,
We did,
but you preserved. What I'm getting at is, did you preserve it? And you're saying yes, you did preserve it. So let me ask you two more questions about the various parties here that are a little. I want to make it very clear here that and tell me if I'm wrong, but it's my understanding that at least the contracts that they are claiming your clients breached, that Donald Glenn was not a party to any of those contracts.
That's correct. In his individual capacity, correct.
even though he's mentioned in the addendum as well, they've never claimed he was the employer.
Correct.
Okay. What was the purpose of the 2008 amendment? What was the purpose of having AGH Wealth Advisors LC sign that?
Absolutely. So the addendum dealt almost exclusively with the issue of how particular revenue streams were going to be handled. And so in 2008, when AGH Wealth arrives on the scene for the first time, what it wants to do is enter into a contract with Mark Ralston and with Alan Gibbs in order to reach a contractual arrangement as to how revenue was going to be dealt with. Now, just as a side note, when it did so, it did not amend the defined term employer in the main body of the employment agreement. Rather, it created a new defined term, capital A, capital G, capital H, AGH. I mean, we could talk about, what could it have done, what should it have done, had it.
Well, right now, I'm just concerned with, who the players are and why some were included in this lawsuit and some weren't. The other thing on the 2008 addendum, does it have any application, at least from your position, to protecting client lists?
None whatsoever.
Or is it only dealing with division of revenue?
It has absolutely no impact whatsoever on the underlying confidentiality provisions in the main body of the employment agreement.
Does it even mention those provisions?
No, Your Honor.
Okay. You may go for
Okay.
it.
So I'm going to jump now sideways to a different issue, which is of importance. Obviously, you all are aware that if I don't get to cover everything, it's not that we don't think it's all important. I want to talk about conversion. Conversion is an interesting, very, very old cause of action. The plaintiffs won $1.571 million against Mark Ralston and Kay White on their conversion claims. There are two critical aspects, however, of a conversion claim, which we think the plaintiffs failed to meet at trial, and which we think requires the reversal of this portion of the case. First of all, the plaintiff has to be the owner of the property. This is absolutely crystal clear under 130 years worth of Kansas law on conversion. In this instance, as plaintiffs concede in their brief, the client information, the client list that was taken from the plaintiffs by Kay White came from LPL. Alan Gibbs was not the owner of that client information. In fact, under federal law, Alan Gibbs, the accounting firm, by being an unaffiliated party with LPL, it couldn't even look at the information. So in other words, not only does it not own the information, it would have been illegal for them to even try to get access to it and look at it, let alone use it for anything. Now, the cases.
What about Donald Glenn? Because somehow he got lumped in here. So did Donald Glenn own any of this information, and what was his role in this?
Excellent question. So Don Glenn was also simultaneously working for two different companies. Sometimes he would wear his Alan Gibbs hat when he was working in the accounting world. Other times he would wear an LPL hat when he was working in the LPL world. And in this world where people are sometimes
Mr.
acting.
Alonso, what was his role with LPL?
He was a registered representative.
And what did that give him license to do for them?
Sure. So it gave him a variety of things that he was able to do. So for example, he would have been able to take a look at the LPL client information. He would have been able to have communications with LPL clients. He would have been able to engage in certain supervisory obligations as somebody affiliated with LPL. He also had obligations. Obligations included being subjected to LPL's contracts, subjected to the regulations that LPL was subjected to, and subjected to the supervision and direction being given to him by LPL.
Was he a principal? Was he a director officer of LPL?
So the securities world does it a little bit differently. They don't necessarily have traditional. What they
That's
do
why I
is
used principal, because I didn't know what term they used, but whatever
Sure.
term was he in, did he own this property, which is what you want us to get to?
Yes, he absolutely did not own the property. In fact,
And why not?
Sure, because federal law, the Gramm-Leach-Bliley Act and Regulation SP has made it crystal clear that financial firms, that is the corporate entities, own the client information, and that they are required by federal law to issue privacy policies specifically educating all of their registered representatives and all of their clients how the client information owned by the firm is going to be handled. and simply allowing one of its registered representatives to use it in a personal capacity, however they desire, is not something that is either permitted by federal law, nor is it permitted by LPL, nor is it permitted by the contracts that Don Glenn or Mark Ralston signed. And so to answer your question, did Don Glenn own this information? The answer is absolutely not. He was only able to use this information in a manner specifically instructed to him by LPL, and that he had signed off on a contract with LPL.
So was his position as to that information any different than Ralston's?
No, Don Glenn was subject to the same contractual obligations and the same privacy policies issued by LPL that Mr. Ralston was.
So they both would have had basically access to this information
In their capacities as an LPL registered representative. And to put a finer point on it, this issue about the firewall between this client information, it's very, very strict. The regulators and the firms and the policies that are in place, are very clear in that LPL information must be exclusively contained within protected areas that are owned, controlled by LPL. There would have been separate files and client information in the possession of Alan Gibbs's that are presumably subject to Alan Gibbs's restrictions and requirements. So presumably, by working for both Alan Gibbs and LPL, Don Glenn would have had access to Alan Gibbs's client information subject to Alan Gibbs's rules and contracts, and he separately had information. He would not have been permitted to cross-pollinate this. He would not have been able to just take a bunch of client information from one place and dump it into the other, or even change hats. I mean, if there was a client exclusively of LPL's, it would have been inappropriate for him to gain access to it and to work with it as that LPL registered representative, and then decide, I'm going to stop being an LPL registered representative, and I'm going to put on my accountant hat, and now I'm going to be doing accounting work with this same information. That's impermissible.
Mr. Alonso, you're about to go into your rebuttal time, which you're free to do, but you don't get it back later.
I want to make one quick point on this conversion issue, and then I'll stop. Conversion, in addition to the plaintiff having to be the owner of the information, it requires that the plaintiffs be excluded from the property. That is, it's not enough that somebody took it, the plaintiffs also have to be excluded. At no point was Alan Gibbs and Houlik, AGH Wealth, or Don Glenn ever excluded from anything that they owned. In fact, to add another layer to it, the client information that Mark Ralston had in his possession that he was taking with him at the time of his resignation, he handed it to Don Glenn and said, here's a duplicate copy of precisely the LPL information that I've taken with me. You have a duplicate copy of it now in your possession. So as a matter of law, and as there's nowhere in the record, there are literally no citations that would indicate that any plaintiff was ever excluded from possession of anything that it owned.
and that raises your instruction issue. But before we even get to conversion, don't we first have to make a finding whether or not the Kansas Uniform Trade Secrets Act preempted this claim?
That's a separate issue.
But it seems like all these nice technical things about conversion and what it entails are great. But if the Kansas Uniform Trade Secrets Act preempts that claim, then we don't even reach those issues. So tell us why this is preempted.
I think it's preempted because as the Kansas Uniform Trade Secrets Act and Kansas Supreme Court cases have made clear, that statute explicitly preempts what would otherwise be claims for the taking of trade secrets. What's interesting about this particular scenario is that this particular issue came up repeatedly and was discussed thoroughly on the record. And it was always the case that what the alleged trade secrets were the client list. That was what the alleged trade secrets were. There wasn't anything else that was out there that was alleged to have been the subject matter of the conversion claim.
Okay, and then, but was there evidence of other property that was allegedly converted other than the confidential client list?
No, Your Honor, there was not. There was one other minor side issue that did come up, but where this issue came up most prominently was in plaintiff's briefing to the trial court on its attorney's fees issue. And what it was arguing to the court there is that its conversion claim and its breach of contract claims are one and the same. And the plaintiffs actually made a little bit of a joke in their pleadings. They said, this case is about the client list. It's not as if Mark Ralston also converted the coffee pot. So to answer your question, was there other property allegedly converted? The answer is absolutely not.
And we'll allow Ms. Mann to answer that question as well. But that your position is that we're only talking about the client list, and traditionally our client list considered trade secrets?
Under certain circumstances, they certainly can be.
Right. So does that mean that if we were to go down the road and say that perhaps the Kansas Uniform Trade Secrets Act preempted the conversion claim, is there a fact question regarding whether the client list were trade secrets or not, or can we decide that as a matter of law?
I think you can decide it as a matter of law, Your Honor. I think the cases that we've cited make it clear that the explicit purpose of the Kansas Uniform Trade Secrets Act was to replace other tort claims and other civil law claims that would have covered trade secrets. And again, this record is full of discussion and rulings about what was at issue in the trade secrets claim and then the conversion claim. And it was the exact, precisely the same thing. It was the client list.
Mr. Alonso, I did have one quick question. With respect to conversion, was there an individual left behind that had the same skill set or capabilities as Mr. Ralston that could make the same use of that client list that could perform that same function so that it was something that would remain useful to AGH?
Yes, Your Honor. I actually, so the first easy answer to your question is yes, absolutely. There was somebody behind that could still use the client list. I would say, though, that under Kansas law, even in that instance where there wasn't necessarily somebody that was left behind that would have precisely the same skill set as Mark Ralston, that still wouldn't satisfy the requirement that the plaintiffs were excluded from possession of the property. So I think I'm at my time. I don't know exactly how much is left. I'd like to.
Yeah, you are. You have about 11 minutes left for rebuttal. So we'll go from there. We'll hear from Ms. Mann now.
Thank you, Your Honor. I am Terry Mann of the Martin Pringle firm, and I'm here today representing the plaintiffs and appellees in this case. I think I can shed some light on some of the questions that the court had. AGH is an accounting firm. That's what it started as in the mid-1980s. But the testimony at trial was that since that time, people with AGH have been offering wealth management advice to their clients. They help do financial plans and figuring out how clients could best keep and transfer their wealth. Now, in the 1990s, the feds began regulating that field a little more. And so at that time, Don Glenn and Brad Bechtel and others became licensed to do investment advising subject to the federal requirements. At that time, they formed Trusted Advisors, LLC. And as you'll note from the caption, Trusted Advisors was initially a plaintiff in this action. It provided investment services to clients, and it still existed when this lawsuit was filed in 2012. And that's why it's included as a plaintiff. It was shut down before we went to trial because by that time we had AGH Wealth Advisors, LLC. But Trusted Advisors was part of the AGH group of companies that was focused on helping with wealth management issues. Now,
Was it a broker? I mean, was it a licensed broker, or did it have a licensed broker?
No, they were using MMLISI Melissy as their broker dealer. As the court knows, when you want to buy or sell stocks, the federal regulations require that to be done through a broker dealer. And so they were using Melissy, which was a spinoff from Mass Mutual Life Insurance Company, and they had gotten into that business.
And wait, let me, before you leave that, is it your position that AGH Wealth Advisors LLC is a successor to Trusted Advisor, or what relationship, if any, do those two have?
I think it had a broader scope than Trusted Advisors. When it commenced operations in late 2007, it did become one of the employers under the 2008 amendment to the employment contract. And we disagree with Mr. Alonso's claim that it didn't change anything about the existing contract, because it did. It substituted in AGH Wealth Advisors as part of the capital E employer. And so that meant that the language in the contract, which says that Mr. Ralston and Ms. White will keep the employer's confidential information confidential, that now applied to AGH Wealth Advisors also.
Point me to the language in the addendum that does that makes AGH Wealth Advisors LLC a capital E employer.
It's at the very beginning when it talks about AGH and what that means. And
so are you saying where it says AGH defined, right, and then it lists several companies, because that's there, that was sufficient to make them an employer under the 2003 agreement?
Yes, I believe that is correct. And that was what the trial court ruled. Okay,
and when did AGH Wealth Advisors LLC come into existence?
It was late 2007.
Okay, so at the time that it signed this contract, it was in existence as a limited liability company.
Exactly.
Okay.
Now,
let me jump in also. I want to get your take on something that Mr. Alonso referred to. From your client's perspective, the list of clients' names, addresses, related information that Ms. White downloaded from LPL to the flash drive and then delivered to Morgan Stanley, whose property is that and why?
You know, backtracking a little bit, in the, I think it was 2008 timeframe, a bunch of the big brokerage houses had been in the habit of suing each other when brokers moved from one to another. And you know, one would leave Payne Weber and go to Morgan Stanley and there'd be a lawsuit. And then one would leave Morgan Stanley and go somewhere else and there'd be a lawsuit. And so they entered into this agreement called the Protocol for Broker Recruiting, which said it was essentially a covenant not to sue. We won't sue your brokers when they come to work for us, and you won't sue ours when they go to work for you. But to be bound by the Protocol for Broker Recruiting, you had to be a signatory. And AGH Wealth Advisors, Trusted Advisors, none of them ever signed the Protocol for Broker Recruiting. They have a website and they identify which brokerage houses are members, and we're not there. We never signed it. And
was the LPL, did they sign it?
LPL did. They since
and wasn't Donald Glenn a representative of LPL, just like Mr. Ralston?
He was.
So he was a party then to that protocol agreement in his representative capacity with LPL, wouldn't he?
Well, Your Honor, I disagree with that, because the contracts that AGH Wealth Advisors has with LPL says that they are independent contractors. Neither of them has the party to bind the other. And there isn't anything about the contracts between AGH Wealth Advisors and LPL that says that any of the existing contracts that AGH Wealth Advisors has are null and void.
So what good does it do for LPL to enter in if its representatives aren't covered by it?
As I say, they've since dropped out of the protocol, but I think at the time it was just a mechanism that they used to avoid spending a lot of time and money suing each other.
Right, and that would have included Donald Glenn as well as it would have included Mr. Ralston, would it not?
Well,
at that time, let's say this was Donald Glenn who did the exact same thing that Mr. Ralston did. wouldn't this have covered him as to the extent that it does or does not cover Mr. Ralston?
No, I don't think so, because the contract that Mr. Ralston had to keep confidential information confidential and to not solicit clients, that existed prior to the protocol for broker recruiting ever being thought of. And it exists in a separate sphere because LPL doesn't have the ability to bind AGH Wealth Advisors.
And I didn't take them out of it. I'm talking about Donald Glenn, only Donald Glenn, who you have as a separate plaintiff in this conversion. How's he own any of this client list? How do you prove conversion, even if you do have a claim for Donald Glenn?
The way it worked was that when an investment advisor, whether it was Mark Ralston or Don Glenn, when they had a transaction in securities, some client would say, I'd like to buy some Tesla stock, and that would get transacted by LPL. And then there would be a commission that would be paid.
I understand all that. How does Donald Glenn, how is he an owner of this client list any more than Mark Ralston would have been, who both were representatives of LPL? That's what I'm trying to figure out.
AGH Wealth Advisors had its own.
I'm not asking about, take them out of play completely right now. I'm talking about the relationship with LPL. You're saying that he was a representative, Mark Ralston was a representative.
Right.
If Donald Glenn was an owner of these confidential client lists, then why would Mark Ralston not have also been an owner of these same confidential client lists? Or at least have the same right to use them?
They had the right to use them, and information was shared with LPL, and that happened on a daily basis. But my clients had an interest in protecting the confidential information because they had contracts with those clients, they had privacy agreements with those clients, and they were earning revenue from those clients.
No, and I understand that as far as the AGH companies. Okay, here's the question to me.
Could I go back?
Go ahead.
I'm still not sure I really got a clear answer to my question. We kind of digressed some. What's your response to Mr. Alonso's argument that this was the client list and the information on it that Ms. White downloaded and delivered to Morgan Stanley was LPL property? And who among your clients had a protected property interest in that information, and why?
We believe AGH Wealth Advisors had a property interest in that client information, and so did Don Glenn. We also would like to point out that it wasn't just the client list that they took. In addition, on an entirely separate computer system, AGH administers 401k plans.
Right, I saw that in the briefs. Before we get off.
Okay, let's get this question answered.
AGH Wealth, what is the source of their property interest in that client list? I mean, how do they have an interest in a list that's on LPL's computer?
They were sharing information by virtue of their agreement with LPL, but each of them had obligations to keep information confidential. And even though they shared it, we had as much of an ownership interest in it as did LPL. In fact, a lot of these brokerage clients were clients that we had purchased from Mark Ralston back in 2003. Long before LPL was even in the mix. We paid Mark Ralston $260,000 for his book of business when he came to work.
Did AGH Wealth have either the same list of clients or the ability to access the list that LPL had?
Yes.
Okay, and is that in the record someplace?
Yes, it is.
And well, help me out. It's a big record. Where would where would we locate? I mean, is there a document or testimony or both? I hope.
The testimony that would be most relevant, I think, is that of Brad Bechtel, who is the president of AGH Wealth, and he testified at length about how the relationship worked between AGH Wealth and LPL, and how that information was maintained and kept and used by both of them. And that would be the most helpful, I think.
All right.
So just so I understand this, then none of them had exclusive rights.
Exactly.
So how do you get to a conversion claim if nobody had the exclusive right to control, which is one of the fundamental Blackstone law definitions of property, and also an element of conversion that somehow got messed up in the instructions?
Your Honor, we don't think that the instruction was messed up. We think,
well, let's say take that part of my question off. And I agree you don't believe that. I think you would agree though that it said or instead of and.
It did.
And you're just saying that wasn't clearly erroneous.
Yes. Yes.
Right. You're not saying that it was correct, are you?
We think at most it was harmless error.
Right.
And
But that doesn't, harmless error means there's error. It's simply that it's harmless. No, so we don't hold that against you.
yes.
So back to the question of, you said that they took the client list and they took some 401ks. Are those the two things they took?
They took the client list, they took 401ks, and those are in the record. And Kay White has gone through, and her handwriting's all over them, where she's
Okay. I'm just trying to find the different
Right.
categories of things they took. So
They
client
took-
list, 401ks, what else?
They took information about clients that were served by other investment advisors, not Mark Ralston. They took information about what commissions were being paid and when. They took information about how documents were stored and used. They took information about earnings. They took information from a particular family, the Guyer family that owns the Moe Ridge Manufacturing Company, that hadn't been affiliated with LPL at all. They rounded up a bunch of information and took it all and gave it to Morgan Stanley.
Was it all confidential information?
Yes.
Okay. So wouldn't it be a trade secret?
Your Honor, I get where you're going, and
I hope you do, because I need to hear you tell me why this isn't the conversion claim isn't preempted by the Kansas Uniform Trade Secrets Act. So I do need you to get to that.
Well, first of all, Your Honor, we think this falls under the doctrine of invited error. This isn't an argument that the defendants made at trial that the CUTSA preempts the tort claims. What they said at trial was that, Your Honor, the plaintiffs ought to be forced to elect between Kansas Trade Secrets Act claim or their other tort claims. And the judge, we thought about it and argued it, and he said, I'm going to make you elect. And so we elected to pursue our other tort claims.
Did you read Wolf before you did that?
We did. We talked about the pizza ovens, but we don't think that it's proper for the defendants to argue to the court that the court ought to take a particular action, and then the court takes that action, and then they complain about it on appeal that it's reversible error.
But if it's preempted, it's preempted. I mean, as a matter of law, I mean, they don't have control over that. That's something that if there's an error, perhaps the district court erred. But isn't that, as a matter of law, at least to the extent that what they took were trade secrets, isn't the statute clear on its face that it's preempted? I think it uses a different term than preempted, but
I think there's a difference between what is a trade secret, which is something that cannot be perceived by ordinary means, like reversing
right.
the pizza ovens, and stuff that's commonly known.
Right. And here I'm talking about only to the extent that whatever was taken was trade secrets. For example, there's a lot of cases out there that say a confidential client list is a trade secret. But there may be other things that are confidential but are not trade secrets. And I know we talked about that in Wolf and Lending Tool. There's a lot of cases where that's been discussed. And so I'm trying to figure out what's potentially preempted. And I know you're claiming nothing is preempted, but do you have any conversion case or property that was not a trade secret under the definition of the Uniform Act?
Your Honor, I think we had a lot of confidential information that probably didn't rise to the level of trade secrets. For example, the 401k plans. You could probably get on various employers' website and find out, do they offer a 401k plan to their employees? And yes, no, you could search around and find out that information, but it's confidential, and that's part of what Kate White took with her. It's probably not a trade secret because you could find out through other means.
So doesn't that really entail a fact question? Just as in Wolf, they remanded it, just as in Lending Tool, our court remanded to determine what is a trade secret and what is not a trade secret.
And we believe that the information they took was confidential, but that the Trade Secrets Act, by its own language, only preempts claims that are the equivalent of a tort claim that's alleging theft of a trade secret.
Right. So conversion of things that actually factually are trade secrets. Would you agree with that?
I would.
Okay.
Okay. Going back to the purchase of the book of business in 2003, again, my client paid $260,000 for Mr. Ralston's client list, and it was a forgivable loan. They agreed they'd forgive 1/48 of it every month for the next 4 years. And after 4 years, they were our clients. And those are some of the people who were on the list that they took with them. Throughout the time Mr. Ralston was there, as we mentioned, the agreement was that he would split commissions with Don Glenn, started out on a 50-50 basis, and that Don Glenn would use commissions from Mr. Ralston and other investment advisors to pay the overhead of the investment advisory business. We believe that both Mr. Ralston and Ms. White have breached Section 9 of the agreement, which requires them to keep information confidential, and Section 10, which governs their conduct after termination. Section 10 required a 30-day notice, no solicitation or acceptance of business from clients.
Was that for 2 years, for 24 months?
24 months. And
right.
It worked out, they refrained from soliciting clients for about 24 minutes because they drove from, downtown to the east side of Wichita and immediately solicited clients. They had been secretly negotiating with Morgan Stanley for a couple of months. And okay,
but my point on that, I mean, arguably you could say they started preparing it even before they left, but regardless of that, that the 24-month period was clearly covered. Well, assuming we accept your argument that this agreement applies in this case, the 24 months would be clearly covered by that provision of the contract. Yes, and the liquidated damages.
They were restricted from soliciting clients for 24 months. Section 11 is one of the remedies provisions, and it says that we can recover basically payment for a client if they pay it within 60 days, and it's based on revenue that's been earned from that client. They didn't pay anything within 60 days, so we don't.
But all the damages on that would be covered by that part of the contract, is your position? Part of the damages. There's a remedies section in section 13, which talks about liquidated damages based on. Right, and what's it cover that's different, just so that we understand?
Right. Section 11 only pertains to taking clients. And section 13 applies to every other kind of breach. And Mr. Ralston and Ms. White breached it in various ways. He was required to give 30 days notice. She was required to give 14 days notice. Both of them resigned with absolutely no notice after she had left the building with the flash drive. He was restricted from soliciting other employees, including Kate White, and yet he did. And They both took confidential information and disseminated it to Morgan Stanley Smith Barney. In Mr. Ralston's case for a $2 million payment, and in Ms. White's case, she got a $10,000 signing bonus when she handed over the flash drive.
And I think just to make it clear, it was a $2 million loan.
It was a forgivable loan.
Just like your client, when you recruited him from another company, provided Mr. Ralston with a loan, correct? Just for a lesser amount.
The difference being that when he left Payne Webber, neither he nor Ms. White was subject to any sort of a restrictive covenant.
No, that may be. But you said payment.
Right.
And it wasn't a payment.
They wrote him a check for $2 million and it was forgivable.
But theoretically, he had to pay it off or work it off.
Exactly.
Okay.
In terms of the breach of contract, Mr. Ralston's argument that AGH was not the employer, we disagree with that based on the 2008 Addendum A amendment. And after that, he continued to recognize that AGH Wealth Advisors was his employer because he split commissions with Don Glenn. He was getting W-2s from AGH Wealth Advisors. Shortly before he left, he demanded to be paid according to the 2008 amendment. And when he turned in his resignation letter, it was addressed to AGH Wealth Advisors. And I asked him, well, you wouldn't give them a resignation letter if they weren't your employer, would you? And he said, no. The argument that Mr. Alonso makes that Mark Ralston was only precluded from performing accounting services requires a strained interpretation of the contract. He was not a CPA. As Judge Atchison noticed, we were trying to keep him from taking investment advisor clients, and we weren't worried about him providing tax and accounting services because he didn't have that training or experience or ability.
So is it your position that falls under the wealth management portion of the employment agreement?
Yes.
Because let's look at that. The first whereas, was he providing any type of tax services?
No.
Was he providing accounting services? I think you just said no.
No, he's not a CPA.
Was he providing data processing?
No.
Was he providing employee benefits?
No.
Was he providing wealth management?
Yes, investment advisory, I think, kind of falls under the umbrella of wealth management.
Okay.
Now, one of the issues that comes up under this section is that the court construed the contract. Mr. Alonso said, well, he's only restricted from providing accounting services because the contract says services that the employer now provides. And Judge Comer said during instruction number 16, the word now means as a result of this contract. It doesn't mean, that we were only concerned about him providing accounting services. The conversion argument, this is kind of similar to a Court of Appeals case, IBD Inc. versus Enterprise Business Solutions, where a CEO of a company, while he was still employed, secretly set up a competing company. And then he came in and he copied all the confidential information off of the IBD's servers and took it to his new company.
He did more than that, didn't he?
He did. He was a bad actor.
Didn't he delete that information?
No, because he took the position, well, it can't be conversion because you still have the information. I just made a copy of it and you could still use it. And the issue on appeal was the jury instruction correct? Should it have said?
But wait a second. Let's not just gloss over that. He did disable it, and then he just said, well, you could go find it some other way.
Yeah.
So he definitely was trying to convert the property to the exclusion of the people left behind. Where here, if I recall correctly, maybe Mr. Ralston was a bad actor, but in his resignation letter, he was upfront about here's what I took. And you still have access to it. Now, you could argue it wasn't in any value anymore, but isn't that quite a distinction between disabling or destroying property versus taking a copy?
You know, I think the manner in which Mr. Ralston and Ms. White left is particularly noteworthy and a little different from the IBD situation, because even though they've been negotiating for months and could have given timely notice under their contracts, they waited until Friday, July 27th, 2012. And she came in that morning and accessed her computer and finished up her collection of information. She puts a flash drive in her bag. At lunchtime, she leaves like she's going to lunch, only she didn't intend to come back. And after Mr. Ralston knew that she was out of the building with her flash drive, then he handed Don Glenn his resignation letters and her resignation letters. And they picked that day because Brad Bechtel, the president of AGH Wealth Advisors, was on a camping trip with his sons in Canada and couldn't be reached by phone. And Paul Allen was out in the wilds of Colorado and couldn't be reached by phone. So they selected.
This is probably a great jury argument, but let's stay focused on the question, which is, it's here. Is there any evidence that they either destroyed or disabled the information they took?
I don't think they did either one of those, but when they went immediately to Morgan Stanley and sent out solicitations that afternoon, and Kay White got on the phone and she's calling people wanting to move their accounts. By the time we had the opportunity to do anything to rectify the situation and to try to counter solicit our clients, you know, the horse was out of the barn.
Right. But that was covered by, assuming the employment agreement applies in this case, that's covered by the employment agreement. Going and soliciting other, I mean, it's clearly in there that if this applies, that they were not to solicit your clients. And that's covered in the contract.
Section 11 covers that, but it by its own language, it really only applies if they make payment for those clients within 60 days. And we made a demand. They never paid a penny. And here we are, you know, almost.
Right. So, but I mean, what I'm saying is you have a contractual remedy for that, assuming the employment agreement applies.
And as Judge Comer noted in his memorandum on the post-trial motions, Section 11 only applies to clients lost in the first 24 months. Well, you know, we continued to lose clients after that. And
well, wasn't it fair game? Isn't that a part of a restricted covenant? It's for a limited geography and a limited period of time, limited. And after 24 months, you could restrict me from my employment, but after 24 months, I'm free to go.
Right. Under Section 11, had they made the payment within 60 days, I would agree with that. Because they didn't, then I think we're entitled to all the other remedies that are available to us, and the contract language contemplates that. I would also point out that on the conversion issue, the jury instruction number 20 that the trial court gave says, to the exclusion of plaintiff's rights. And the defendants say that the language in that instruction undoes the to the exclusion language, but they didn't make that argument to the trial court. They didn't make that argument in the jury instruction conference. And so we believe that lack of a contemporaneous objection means that argument is waived.
Well, it's not waived. It changes the standard of review to clearly erroneous, doesn't it?
It does.
Okay. It's not waived, though.
On the damages argument that Mr. Ralston makes, as we discussed, Section 11 only pertains to payment for clients. Section 13 covers all the other kinds of breaches that can occur in that contract. And we believe that the jury's award under both Section 11 and Section 13 were appropriate. Mr. Ralston argues that the damages are duplicative, and Mr. Alonso claims this is all for taking the client list. And as we've discussed, it's more than just the client list. And in fact, in the verdict form, the jury was instructed not to duplicate any damages. And in questions number 28, 29, and 30, they were specifically asked if any of their damages were duplicative, and they answered no. They did send out a question during deliberations and said, are we supposed to subtract any duplicative damages? And the court said yes. And I think we have to assume that the jury abided by the instructions they were given. Mr. Ralston also argues that the damages exceeded the amount in the pretrial order. And Judge Comer addressed that in his memorandum on the post-trial motions, and he explained why they did not have a reasonable belief to think that we were only seeking contractual damages when we were alleging a bunch of different kinds of torts. And in addition, we have a mechanism for defendants to find out exactly what amount of damages are being claimed, and that's Supreme Court Rule 118, and they never served a request to seek that information.
Did you submit evidence to the jury on specific amounts for the breach of fiduciary duty? And if so, what was that evidence?
That was really left to the jury's discretion, Your Honor. There were instructions about what it took to have breached fiduciary duty, and both of them were determined. Mr. Ralston was found to have $60,000, and Ms. White was
right. I recall that. Now, correct me, but did you offer expert evidence on any component of the damage?
No, Your Honor.
Same question as to the conversion, assuming that the conversion was appropriately before the jury. What's the basis for $1.5717 million worth of damages for conversion?
It's kind of an unusual amount. The jury was instructed the measure of damages on a conversion claim is the fair market value of the property that was converted. And there was testimony from Mr. Ralston and the documents with Morgan Stanley that showed that when he arrived there, and they had calculated the amount of his forgivable loan on the basis of what clients he brought to them. And the jury knew that he had been paid $2 million, and that Ms. White...
that he had been loaned $2 million, I believe. Haven't we already established that?
We did.
Because that's a difference, and I'm wondering if the jury had that misconception. I hope at trial you didn't continue to say $2 million payment.
We actually introduced as evidence the contract that he had with Morgan Stanley.
So are you saying that the jury would have relied on the $2 million loan as kind of the value, and then after the question that they subtracted off the $381,000 and the $50,000, which gets you about to this figure they're at?
I believe they did rely on that. And in his post-trial motion memorandum, Judge Comer said that they had that evidence before them, and he thought they probably relied on that as a measure of determining the fair market value.
And was there any breakdown when, this one's strange because all of a sudden we slip in Donald Glenn as being a plaintiff. Was there any breakdown as to what he owned that was converted? And what was that? What did he personally own that was converted?
I think his testimony was that he had an interest in the client list. They were all his clients. He had client agreements with them. He was being paid a portion of the commissions, and that as a result of the actions of Mr. Ralston and Ms. White, that he had lost income.
Okay, so loss of income is loss. That's what I thought it was probably for. Is loss of income recoverable in a conversion action? Future loss, or are we not talking about what the value of the fair market value at the time the property was converted?
Right. I think
then can there be a recovery for future loss under conversion?
These were losses that he had incurred prior to the time of trial. They weren't looking forward into the future.
And what's in the record to support that?
Don Glenn's testimony. I believe there were some income tax returns that were introduced.
And then what was the basis of the breach of, well, go ahead, Judge Ishworth.
No, go ahead, because it's a different line of.
Well, just to follow up on the same question with Donald Glenn, because I'm trying to see how he's involved in all this. What was the basis for the breach of fiduciary duty, that there was a fiduciary duty owed to him personally, if he was not a party to these agreements?
The testimony for the jury was that as a result of the position that Mr. Ralston and Ms. White were in, she was working not only for Mr. Ralston, she was working for a bunch of other investment advisors, that as a result of them being in that position and being entrusted with lots and lots of information, that they owed a duty to the various plaintiffs to proceed in a manner that a fiduciary would. And we contend that they did not do that.
But how is it owed to Donald Glenn specifically? As opposed, I understand what the claim is as to AGH and AGH Wealth, but I don't understand it as to Glenn.
I think it was based on the role that he had, that he was responsible for paying all the expenses and overhead of the investment advisory operation, and that he and Ralston had this long-standing agreement whereby they split commissions, and that the actions of Ralston and White deprived him of that.
Okay.
I would briefly address the attorney's fee issue, even though Mr. Ralston did not. There was an award of $605,000 that's subject to an abuse of discretion standard. There was lots of information that was submitted that the court considered regarding the time spent on the case and the hourly rates, and the court considered things like the KBA survey, where they determine what hourly rates are being charged by lawyers in Wichita. The case had a rather complex and tortured history. As I mentioned, it was filed in 2012 and finally tried in 2007.
I don't think they're disputing either the hourly rates or the amount of time. I mean, their dispute goes to a lack of segregation of time on the contract claims that carry attorney's fees and the tort claims that don't. And you might speak to that issue. I mean, I don't think they're disputing the other part of it.
Very good.
Yeah, I guess you might do it quickly. You've got about 3 minutes left. I know this.
As the trial court found, those issues are inextricably intertwined. When I'm taking Kate White's deposition and I'm asking her questions about, okay, how did you prepare this list, and what did you access, and what information did you copy, and what did you download? That kind of information fits into various claims, but it's hard to say, okay, I asked her 15 questions about this, and the time spent was, an hour and a half. And so I'm allocating 0.2 of an hour to the conversion claim, and I'm allocating 1.6 hours to the whatever. And the court understood that because the factual scenario was intertwined, it would be impossible to break down and say, okay, the conversion claim ought to get 0.2 of an hour here. And the court found that it would be so cumbersome and difficult to break that down when the facts are intertwined in and among the various kinds of claims. And I think that's appropriate and supported by the case law, that you don't have to to prevail on every claim in order to achieve attorney's fees. And I would point out that the attorney's fee award was reduced, even though I exercised a lot of billing judgment when I submitted it. And that I think the court adjusted it accordingly.
You've got about a minute left.
Yeah.
Why don't you, oh, I'm sorry. Did I cut somebody
Well,
off?
I was just going to follow up on that. I think they made an argument that even if it couldn't be segregated, which may or may not be the case, that it could have been divided up by percentage of recovery on a breach of contract claim, which you are entitled to attorney's fees on, versus the conversion and fiduciary duty breach claims, which you would not be entitled to attorney fees. What's your response to that?
Again, Your Honor, I think the trial court properly found that all of it was so intertwined that to expect a lawyer to break that out would be impossible. And I think that's part of the reason why he reduced the amount that we requested in recognition of the fact that we weren't successful on all of the claims, only part of them. And I think he also recognized that the defendants adopted a very aggressive litigation strategy. We were still fighting over a term commitment note during trial that Mark Ralston signed. He admitted he signed it. He admitted he owned the money. He'd never paid it because he didn't want to. And that was still being litigated at trial, and the court ended up doing a directed verdict on it. But there wasn't any lack of vigor on the part of defense counsel. And I suggested to the court, if they wanted to look at attorney's fees, maybe they should ask the other side to produce their bills, because we all went to the same depositions and spent the same time in court, and I didn't get any takers on that. But I would suspect that ours were probably pretty reasonable in terms of the length of the case and the amount of work done.
Thank you. You've gotten to the end of your time.
Thank you.
Mr. Alonso, you have 11 minutes of your rebuttal left.
Thank you, Your Honor. I'm going to start off just by giving you a couple of record citations for some of the issues that have been raised, but not really spending a whole lot of time on it. The first issue relates to trusted advisors. Trusted advisors never engaged in investment advisory business and never became a functioning RIA. The record citations I have for that are volume 4, page 334, and volume 3, page 334. It's one or the other or both of those. The next issue that I want to address relates to the ownership of client information. There's been a significant amount of discussion about this, and the issue of client information is specifically addressed in the contracts, literally hundreds of them, that were signed between Mark Ralston, AGH Wealth, LPL, and in many, many instances signed by Don Glenn himself as a registered representative of LPL. And I want to provide a couple of citations to those documents. Volume 43, pages 406 to 438, volume 24, pages 224 to 227. In addition to that, volume 43, pages 387 to 405. The signatures are on 392. The privacy policy incorporation is on page 396. The privacy policy, where it references what Ralston and incidentally Glenn were free to do with the client information, is on page 404. An unredacted version of that document is in volume 3, pages 332 to 334. And if there are any questions about this, Brad Bechtel testified about it in detail, being this being the contract that was at issue that was signed by all these parties in volume 24, pages 224 to 225. The other thing that I want to cite to related to the interplay, and this was some of the argument that was made by opposing counsel, some of the interplay about who shared client information with whom. Under federal law and under the contracts at issue, LPL's client information belongs to LPL. It is LPL that makes the decision with whom it shares it with, when it shares it with that party, and under what circumstances. In fact, in volume 43, page 47, this is a citation to the LPL Financial Advisory Program Agreement that it executed with AGH Wealth Advisors. and AGH Wealth Advisors agreed in that document that it shall review and abide by LPL's procedures related to the advisory programs that are set forth in writing from time to time. And so a lot of the argument that was just made, this concept that Mr. Ralston and Ms. White operated in secret or negotiated in secret or did something untoward is not accurate. In fact, what they did is precisely what they were entitled to do under the contracts at issue that Don Glenn had signed, that AGH Wealth had signed hundreds of times. What they did was completely transparent. They did what they were entitled to do. They were very upfront about it. This was not any effort to paint these people as bad actors, does not take into account the explicit terms of the contracts that were being signed by these very sophisticated people on a regular basis, and for which we have provided this court and cited to the record. I would also point out, as it relates, shifting gears quickly to a lot of different things, I apologize for that, related to the damages question. A question was asked about what damages were provided to the jury. Under Kansas law, a damages calculation or some description of the damages incurred is required by a plaintiff to be presented to a jury. And we, in our appellate brief, articulated specifically that no damages were provided to this jury under a couple of the different breaches. And we provide that testimony in our brief. Some specific examples include the failure to give advance notice, the alleged solicitation of K. White. And in fact, when plaintiffs had an opportunity in their response to respond to this, on page 29, they said, Bechtel and Don Glenn provided extensive evidence of the monetary losses caused by defendants' conduct and provided no record citation. And the reason for that is because there is no place in the record where damages were explained or calculated or provided to the jury. In fact, contrary to that, Brad Bechtel, a principal of Allen Gibbs, testified that the monetary calculation contained in Exhibit 84 was the calculation for damages under Section 11, that is the liquidated damages provision. He also testified that that was the fair market value for the client information that was at issue in both Section 13, the liquidated damages provision, as well as under the conversion claim, as well as under the fiduciary duty claim. The other thing that I would want to add is again, this is this concept of there being this other thing in addition to the client list, this 401k related information. We dealt with that very thoroughly in our briefing and our reply brief on pages 5-6. There was this one other very minor, very small collection of information related to 401ks. The issue as it relates to that information, however, that information is also not the property of plaintiffs. It's the property of a company called Mid-Atlantic. We provide a series of citations to the record for that proposition. But moreover, the Paul Allen of Allen and Gibbs testified extensively about this 401k information. He testified that Allen Gibbs did not provide the 401k plan administration business. On that list, he only identified 2 of Allen Gibbs's clients who appeared on that list. He also testified that there was no evidence that Mark Ralston solicited either of those clients for record-keeping services. And he testified that Allen Gibbs was not damaged. And in fact, the trial court and the jury found that Allen Gibbs had not suffered damages. And so the 401k issue is really an attempt to come up with something that was at issue in front of the jury other than the LPL client list. I want to address the other issue that came up as to what else was at issue, what other property or what other information. Clearly, we've got the LPL client list. We've consistently believed in that throughout the record, that was the client list that was at issue in this case. This 401k issue is a distraction. Similarly, this notion that there was some other thing, some other information about products or services. And in fact, this was discussed on the record. The citation is volume 31, pages 80 through 86. There was an exchange between Judge Comer and opposing counsel, Mr. Drumright, where it was discussed. And Judge Comer said, but I mean, we are not dealing here with how you create product or build a product or what you process is in handling assets. I don't see that as something that has been an issue at all in this case or any testimony to that. And then the conversation continues. There was nothing else. There was no other property. There was no coffee pot. The core nut of this entire case for the entire record was the LPL client list. The other thing I want to address is that during argument, opposing counsel gave some examples of things that Mark Ralston did that would indicate that he believed that AGH Wealth was his employer. But that's little e employer. That's not capital E employer. That is the defined term in the contract. That's not how defined terms work. The way a defined term works is you look at it and you look at how the contract then gives you the specific definition. I guess hypothetically, plaintiffs could have said Alan Gibbs, trusted advisors, and any other company that is your employer. But that's not what they did. What they did is they specified specific corporate entities. And so to say that if Mr. Ralston then began working for other companies, that they would somehow naturally become a part of a defined term is inconsistent with Kansas law, and it's inconsistent with the contract. The other thing I want to point out is that as it relates to the IBD case, what the IBD case addressed was a situation in which the jury instructions provided to the jury on a conversion claim did not make it clear that the finding of the taking of the property was to the exclusion of the plaintiffs. It didn't make it clear that that was mandatory. It gave the jury the impression that that was not something that the jury had to find in order to award damages. And in the IBD case, they ruled that that was an error. And that's precisely what happened in our case. The IBD case then went on, however, to point out what Your Honor had already addressed, which is that in the IBD case, not only did they take a copy of the information, but they then wiped the servers. In this situation, and across the entire record in this case, Mr. Ralston and Ms. White, they never, ever wiped anything. They never destroyed anything. They never shredded anything. There was never any action taken to exclude Alan Gibbs, AGH Wealth, or Don Glenn from any information that was their information. Furthermore, there was never any action taken to deny LPL access to its own information. Instead, what Mark Ralston and Kay White did, when you look at the terms of the contracts, the plain language in these agreements and in these documents, is precisely what everybody for years was signing off on that they were entitled to do. Lastly, and in closing, I want to talk about an argument made by opposing counsel, which was that it was Alan Gibbs's intent to stop Mr. Ralston from soliciting all investment services or all wealth management services. And there's really two responses to that. First of all, whether that was their intent or not is irrelevant. What's relevant is what does the contract say? And that's not what the contract does. What the contract says in plain language is that Mark Ralston will not solicit the capital E employer's clients for services now being provided by the employer. And remember, under Kansas law, restrictions are not favorable under the law. They're to be strictly construed against Alan Gibbs. The next issue becomes whether they had, again, I think it is irrelevant if they had a desire to try to include additional services beyond those which they were now providing. But if you look at Kansas law, it makes it clear that when a company has a restrictive covenant, it is enforceable only if it is narrowly drafted to protect the company's legitimate business interest. And there is extensive discussion about this in the Weber case and in the Alan Gibbs case. And what is legitimate business interest is something which is competitive. Because Alan Gibbs never provided broker-dealer services, if Mark Ralston is soliciting broker-dealer services, that is not a service that is competitive with the services that Alan Gibbs provides. Similarly, if Alan Gibbs never provided investment advisory services, if Mark Ralston is soliciting investment advisory services, that's simply not competitive with what is being provided by Alan Gibbs. And so in a different hypothetical fact scenario, where Alan Gibbs had said explicitly, not only do we want to prevent you from providing the services we are now providing, accounting services, we also want to prevent you from soliciting broker-dealer services, something we don't provide, or investment advisory services, something we don't provide. If that had been the language in this contract, it would have been unenforceable under Kansas law because it extends beyond that which is competitive against Allen Gibbs and includes things that it does not have a legitimate business interest to prohibit. And one last point, do I have one more minute left?
Well, make
I'm
a
sorry.
quick point.
Sure. My quick point is this. Allen Gibbs existed in an arrangement where Mark Ralston, Kay White, and Don Glenn consistently, day after day, year after year, had a separate contractual arrangement with a separate unaffiliated company that had mandated, if you want this arrangement, you have to sign our contracts. You have to play by our rules. And so day after day, year after year, as opposing counsel said, Don Glenn had contracts and client agreements. He most certainly did. And it is those precise contracts that entitled Mr. Ralston and Kay White to do exactly what they did. Thank you very much, Your Honors.
Thank both counsel for their excellent arguments, the briefs. This undoubtedly was a very challenging case in the district court, and I think we have a challenge ahead of us. We will tackle it expeditiously and get you a ruling as quickly as we can. And with that, we are adjourned. Thank you all.
Thank you all.
Thank you.